Look at a first year brief assignment when we're dealing with constructive discharge in Title VII. I've got some really easy terms in the search bar here to just start to get some materials back that have to do with constructive discharge and Title VII. So that's exactly what I typed in. I'm going to run this search. Now, when we're trying to find just background information on learning more about constructive discharge, we usually start our research in secondary materials. But I'm going to come on over to practical guidance because when I see that I've got some hits here, these are made for new associates by some of the best attorneys in their field. And so they're really nice summaries on how to practice certain areas of law. We're really only interested in the practice notes because we're not filing anything. So now we can come on over, and I would really only give this about a minute of your time. But we can see right here, there's a whole page on constructive discharge and employment litigation. And scrolling down, I have some Title VII compliance issues that I may want to take another minute at. I've got some defenses that perhaps if I was on the other side, I might take an extra minute at. But everything else is starting to look like it's talking about other statutes and other issues beyond my scope. So I've got the first three here. We're just going to take a look at the first one right now because it's so on point. And it's telling me that this is going to talk about the constructive discharge doctrine, how to establish a claim, the defenses, and different best practices here. So we start to learn about it here, and it's going to start talking about it. From here, we're going to learn about the doctrine, and you can see that it's starting to give me some of the key cases that I need as well. Now I'm going to hit my back browser, and we're just going to move on now to secondary materials. Your narrowing filters are treatises and guides, and then you might, as a backup, do jurisprudence. Now, if you're really practicing in the real world and very few of these are getting some hits, then you want to go into any of them that are really showing any results because you may be looking for a needle in a haystack. But when we have this many, I usually start with treatises and guides, and then I narrow my jurisdiction. Now, we're talking U.S. federal for this particular brief assignment, and we also want to remember to click non-jurisdictional. So I'm getting away from those specific case, state, resources, and I'm getting the ones that are talking about any of the states and federal law as well. So I've got treatises and guides from U.S. federal and non-jurisdictional. Now I like to open up my sources so I can start to see the types of sources populating in my result set. And right away, I see there's an entire book on employment discrimination. So perhaps I take a look at that first. That one's so on point that I want to see, well, what is this particular book talking about? So I'm looking at the working conditions. This is a digest of additional cases. Perhaps I want to save that for later when I want to dive into understanding more working conditions, but I'm trying to get a better understanding of this in general right now. So this is a whole page on constructive discharge. I'm still in working conditions, so it looks like this is where I want to be. And I'm going to open that up. So once again, just like in the practical guidance materials we were in, we're trying to soak up as much as we can in understanding the doctrine of constructive discharge. Every time there's a footnote, we can jump down and find out a little bit more about where that piece of law came from. It's going to help us start to see the names of cases where the law came from. So this is us trying to gather as much as we can. Now, what we learn are a few things here. Right here, the mere existence of discrimination will not normally constitute the kind of intolerable conditions that would make a reasonable person feel like they need to quit. So we know that this is going to be probably a factorial or some sort of test to be able to hit over what just is merely small issues going on at work. Several circuits have passed and aggravating factors to be present. So we need to find out more about that. And if that's us, do we qualify for any of these aggravating factors? We keep going on, and it says the most commonly alleged grounds mean that they're going to start to work on this particular test that it's beginning to outline, to have severity of pervasiveness. And so what this usually means, and if we were to keep on reading, is that we need to have a bunch of factors that add up to that severity. So we're looking now at particular factors, which means our research is going to take a different approach, because for every issue in our fact pattern, we need to match it up to try to find other cases out there where those type of situations constituted an intolerable working condition. So we're now looking at particular facts in our hypo and particular cases that match up with those facts. So now let's go back to the results because we have a better idea of what we're looking for. The next place we tend to go when there's a statute on point to find more cases is also to go to the statute. So let's go to the statute because we can use that to help us find more cases. This is the actual statute we need, so I'm going to come on in. So now that we're in the statute, you're going to take the time to read the statute and understand it. Because you guys have AI on your IDs, it's going to summarize it. The statute starts here actually, but we're going to use this to find more cases. And those cases are outlined in the annotated code section. Remember, those are the notes, so I can jump right to them. And because we're doing a factorial test right now, we need to find a bunch of these sections that have to do with our topic. So this gets really tricky because we need to take our time and start to go through this list to find the places that might correlate to the issues in our own fact pattern. There's a number of these that I may want to take a look at. I came down to check out where the section is employer practices. I want to know what the employer did that may have caused this intolerable working condition. So I'm looking around to see what types of cases come from that. But remember, we're really looking for very specific things right now. And I encourage you, when you have a factorial test, to take out a piece of paper and write down all the different terms that might be in a document that resonate with some of the facts that you have in your brief assignment. So for this, I might do a control find. Or control find, or we can use search terms and use a little magnifying glass for terms that resonate with my hypo. Our employee was reassigned territory. So maybe I use territory to try to find other cases that are talking about territory or reassigned, as I did here, territory reassignments. This is really tough. We need to go through and find all those words that trigger the right cases. So if it's not reassigned, maybe it's sabotage. If another employee tried to sabotage her, maybe it's something about return maternity leave. So I'm looking for maternity leave. For all of these different things, we need to keep coming back and editing to try to find the right cases. We're going to actually take this to case law right now, where you'll see how this works a little better than just staying inside the notes of our statute. Before we move on, then, don't forget that you have citing decisions here. These are all the cases that cite your statute. Now, we're talking about federal statute, so I've got a lot going on here. And we want a particular section, which is subsection A, and I think it's on page 4. So I look for subsection A, and I can see, okay, here's A1. We still have a whole lot of citing references, but don't forget, again, I need to filter. And so I want to filter to the federal courts. I want to filter to only the reported cases. So I've come down a fair amount here. And now we're narrowing again using those terms like reassignment or territory, and we just keep trying all different terms that we want to try to find in cases, because we're looking for cases where that similar thing happened that happened to our hypo. So we can use that case as analysis to say, C courts, in the Muldrow case, the same thing happened and the court found that that was enough to equal an intolerable working condition. All right, we're going to go back to the beginning, look at case law right now. Now, of course, I want to narrow immediately to court, so I go to U.S. Federal, and I'm going to go ahead and narrow immediately to the published decisions. Now, here's the thing. I usually show you guys Ravel View, which is going to show you the top cases. The bigger the bubble, the more influential that case is to other cases. So we can see state police case right here that we keep seeing pop up. Here's Green v. Brennan. So I definitely want to check out these cases. But then the question is, why are these the only two? What's going on with all these other ones, why they're so small? Well, the issue really is that this is a factorial test that comes from these two cases. So all these cases have to do with very specific set of facts. So Ravel View is helpful to help us spot those key cases that are like the grandparent that lay out the elements, but all of these are very specific to a set of facts, And we need cases that are specific to a set of facts. So for that, I really want to dive in once more to search within results. And once again, we need to narrow to a reassignment. And we don't want to get too hung up on the term reassignment, because if that's not the term the court is using, then I may need to try something else. I often will pop up another window and use a thesaurus to see what other words are out there that have that same meaning that the court may have used. So I keep playing with this box to try to find, well, what are the cases that have that term in it? And I'm looking to try to find them here. I've narrowed down to 900. That's still a lot. So don't forget, I also have this trick. So I'll pop this open so you can see it a little better. In the search box, I used at least 3, reassignment, /s, territory, or account. So now I want 3 times to be in my document a reassignment in the same sentence /s as territory or account. And I could have gone on and put different terms in here to try to say reassignment in the same sentences, territory, account, or key, or anything that's going to help get that discussion going. But putting an at least 3 at front, it means the court needs to discuss that at least 3 times. So hopefully I'm going to go down from, I think we had 900 to now 7. So I want to take a look at these. Well, why is it talking about a reassignment? Is this helpful to me? Did they have a similar reassignment here? Am I using the wrong terms? And we can always go back and edit this box, take it out. Now we've got different factors going on. So if there's an issue of sabotage by another employee, then we need to come back in and try that other factor, because we need to work with our site list right now for every one of those facts in our hypo to try to find cases that discuss that same issue. So we're going to work within our search within box a whole lot to find more. Let's try one more. Bad or poor or negative /s, same sentence as evaluations. And let's see what we get. Okay, so we're getting a bunch of cases here, and I'm just going to come on into this one for purposes of training, because we need to talk about one more thing. Once we're here in a case, if we want to find more cases like a particular issue, we just come on down and we look to find that one issue in our head notes. I also use my search terms a lot, and I try to find, well, where were those specific terms mentioned? I'm going to turn off all of them and really just want to go to where it's talking about those evaluations so we can jump on down. So every time I see evaluation, I'm looking for that passage that talks about these negative evaluations. And remember, every time I see one of these little buttons next to a passage of text I really like, I can use it to find more cases. So these are more cases that have to do with that passage of text that you like. Quickly talk about Shepard's in just a second. Shepard's is for 2 purposes. First, we can use it. This is your Shepard's report talking to you. It's also off to the side here because Shepard's is a list of all the cases that ever cited your source, and on the other citing sources tab, other sources beyond case law that have cited your source Heron. So I've got a list of these cases and other sources here that I can use for research purposes. So for those 2 big bubble cases we saw, we can always go in and use our citing decisions to find more cases that cite our big bubble case. And then of course we need to use our narrowing tools to focus in on cases with the same factual issues as us. But we also want to use Shepard's to find out if our case is good law. And looking at it here, I can see right now this case has been given a yellow triangle. If you want to know why, we can just say, well, why was that? What's the most negative treatment it was given? Well, it was distinguished by this case. So I'm looking to see, well, what did they distinguish on? It's distinguished, usually it means that the facts of this error case were different than Huron. So they're saying the law didn't apply to us because our situation's different. Now, yellow is usually fine. You just need to find out, well, were the facts of ERA exactly like your situation? Because if so, then we might not want to follow the law in Heron either. But if your facts are different than ERA, you're fine. Now, remember, Shepard's for checking to see if your case is good law is at the very end. So you would already know if there was a case out there with such a similar fact pattern to your own that it would cause this to be an issue for you. So most of the time, almost always, when you see yellow triangles, you're good. We're going to come on in and take a look at those other signals. I'm going to do that by just opening up the legend real fast. So here's our legend for Shepard's. And when you see this negative, you want to pop open the why button and find out, well, why? Why was it given negative treatment? Because again, we only care if it's been given negative treatment to the issue of law that we are citing the case for. So if we saw this red stop sign here, we'd want to say, is it saying something negative about the legal issue I'm interested in? Think about it like all of these signals, like different Yelp reviews. If maybe it's giving a negative review about a restaurant and you don't care because it's talking about food that you wouldn't eat anyway, it's the same principle here. We only care when it's talking about our legal principle. Watch out for orange cues. These usually indicate that there's been a statute to come out more recently since that older case. So it's just saying there's something that's come out since your case that's changing the validity of your case. There's an intervening circumstance. Everything else is good to go, so you don't have anything to worry about. Thank you so much for watching. I'm here to answer all your questions. Take care.